I'm like, oh, that's
Yeah. All right, here we go. All right. All right, cell phones off, please. We are ready. We'll rise for the jury.
that's locked, remember?
Yeah, do you want it locked?
No.
You want me to unlock it?
Could you?
Yeah.
Thank you.
I never did a Jack O'Donnell from down here either. Do you like when he does it?
He doesn't get down and read.
When he comes down, he reads his closing?
Oh, you know what? I have had him do that. I don't know.
Yeah.
I used to have a judge who stood when he read the jury instructions. From the bench, stood and read them.
Danny?
Yep.
Yeah. All right, thank you. You may be seated. Parties prepared for the closing arguments?
Yes.
Yeah, sure.
All right, we'll hear from the state of Ohio. Ms. Patel,
Thank you, Your Honor.
you're welcome.
Good afternoon, ladies and gentlemen of the jury. I want to thank each and every one of you for your attention and your concern throughout this process. We've been together for many days now, and I know you've been paying good attention to every witness and all the testimony that you've heard. I think we can all agree that it's tragic circumstances that have brought us together. But as Ms. Faralia told you at the outset of her opening statement, it is a privilege to present this case to you on behalf of the state of Ohio. And before you get to deliberate on this matter, I will provide my opening closing argument. Then you'll hear from Mr. Mack and Mr. Johnson, and then you'll hear once again from Ms. Faralia, because the state of Ohio bears the burden, and you'll hear from the state last before you deliberate. Ladies and gentlemen, we are all together today because of the choices Bionca Ellis made on June 3rd of 2024. That day was like any other day in the life of Margot Wood. And I think we can all relate to what she did that day. Take your kid to the grocery store. It's something that is fun. It's a little get out of the house, buy candy, flowers with your child. And yet, that ordinary act turned into an unfathomable nightmare because of what this defendant chose to do on that day. So what I'm going to do is I'm going to walk us through the indictment, the charges that we have charged Bionca Ellis with, and then we're going to shift our conversation to the affirmative defense that she has raised. All right? So I want to start with count 1, which is aggravated murder. That Bionca did purposely and with prior calculation and design cause the death of Julian Wood. And under Ohio law, the key terms here are prior calculation and design. All right? Those are the words you want to pay attention to when you're deliberating on count 1. What does prior calculation and design mean? Well, you'll have those instructions with you when you deliberate. And in part it says, it's the process of reasoning that must have included a mental plan involving studied consideration of the method and the means, or the instrument with which to cause the death of another. The amount of time that the defendant spends in planning isn't really as critical, but she needs sufficient time and opportunity for the planning of the homicide. So did Bionca Ellis give thought or preparation to choosing the murder weapon in this case? Yeah, she absolutely did. And we can all see it in State's Exhibit 192. And you'll have this, 193. 182, Your Honor, I apologize.
Sure.
Ladies and gentlemen, you will have these videos back with you when you deliberate. I'm going to let this play for just a second, and then we're going to be quiet. I'm going to be quiet for about 50 seconds while we watch Bionca Ellis choose her weapon. "50 seconds. We watch that defendant go directly to the houseware aisles in Volunteers of America, go through that bin, look at the knives, inspect them, handle them, look up top of the knife block up there. She spends almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the two favorites of hers, and then she walks out of the store. She made a decision. That was careful. We spent a lot of time on cross-examination with Dr. Knopfsinger today about how Bionca Ellis didn't just stab anyone in the Volunteers of America store. No, and that supports our argument. This was calculated. She walked out of that store and went to the store next door, encounters more people on her path. And then when she gets to Giant Eagle, that's when she chooses her victim. But she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Now, murder is count 2 and 3, and they're charged under different sections. So count 2 is that Bionca Ellis did purposely cause the death of Julian Wood. And count 3 is that she caused his death as a proximate result of an underlying felony. And what we mean by that is that he died because she committed or attempted to commit felonious assault and or endangering children. And with these charges, there are degrees of culpability and mental states. Okay, so when we're talking about purposely, and again, you'll have all this in your instructions, but these are the definitions of purposely and knowingly. And we're talking about this defendant knowing that her actions would bring about a certain result. Okay, so we know that when she selects that butcher knife and she ultimately stabs 2 people with it, that she's going to bring about a result, right? She's going to hurt them, she's going to kill one of them. And you think about it, with a butcher knife, if you stab somebody, that's going to be the result. You harm or kill. Okay, so when you deliberate these counts, ladies and gentlemen, you can consult your instructions. I'm not going to go through these ad nauseum, okay? I know that you are a smart, attentive jury, but I do want you to pay close attention to count one and talk a lot about that prior calculation and design and the plan that Bionca Ellis had that day. And of course, she had no relationship to these people, and that's okay for proving prior calculation and design. You want to focus on the time and the consideration that she spent choosing her weapon and the steps she took after that. Now, we're going to go through the timeline. We have the benefit of really having all of these actions captured on video. So we know that in a couple days prior to June 3rd, Bionca Ellis had a run-in with the North Olmsted Police Department. And that's important because it's part of the anger that fuels her on June 3rd. You heard testimony about how she was in their jail for a night and that she was purported to have all sorts of property and money and gift cards and other items. So when she's walking around on June 3rd, we know that that's on her mind. She says as much herself. But let's walk through this timeline that we have, right? And again, you're going to have these videos, you'll have the compilation video that we went through together. But what I put together today is kind of a streamlined timeline, all right? So we can see kind of minute by minute where she is. So at 2:36, you see her in that yellow circle. She's in her wheelchair. She's on the North Olmsted Police Department property. A couple minutes later, here she comes into the lobby, and you meet Danielle Shook, one of the first witnesses you heard in this trial. And if you remember how their encounter went, Bionca Ellis wasn't so happy when she left the lobby. Remember, she turned the lights off as she departed the lobby. And then she kind of skips down the stairs. She ditches her wheelchair and her suitcase. And you can look at the video. Again, of course, you heard testimony that she walked with purpose and that she was angry. You can watch that video again that we watched here this afternoon. The careful selection of the weapons, minute by minute here. 14:55, so 2:55, less than 20 minutes after she went to the police station, she's got her weapon. $14:56, she's going to enter the things outlet. She walks in, looks around. Pay attention. She's got two knives still behind her back, and she's looking around. Ladies and gentlemen, she's looking for a victim. These people, they're adults. There's men in the store. Those aren't suitable victims for Bionca Ellis. She's got to find the most helpless victim she can to carry out her crime. She exits. What does she do then? Well, she's got two knives. She can't use two knives. So she's got to ditch one. She's got to keep the best one. What does she do? She taps her knives against the brick column, ditches the flimsy one, keeps the superior knife to carry out her act. Look at her walk. She's not going into that store for anything but to wreak havoc on somebody that she hasn't chosen yet. And unfortunately, or fortunately, how you want to frame it, Again, it's all on video, what she does that day. 2:57, there she is, knife in hand. Again, this is 22 minutes have passed since she went to North Olmsted for her money. And here it is. Ladies and gentlemen, this is the decision she makes after she's selected her weapon. These are the people she wants to harm. It's been decided. This is a volitional choice, ladies and gentlemen. This woman is not experiencing, and we'll get there, but this is a woman who has made decision after decision and planned this out. And finally, at 3 o'clock, we know what happens. Now, part of my job here is to make sure that you understand the elements. I'm not going to dwell on this at all, but we know that a child died. To prove that there was a death in this case, we had to show some autopsy photos. All right, I'm not even going to enlarge them on the screen here. You can see these two photographs. We know that we have a deceased victim. We also know that Margot Wood was stabbed and that she was injured, okay, for the attempted murder charges and the felonious assault. She has scarring on her body, and she will always have that scarring. So the state has met its burden as to those counts as well. This case is unique, of course, as we all know, that the burden shifts, right? The state has proved beyond a reasonable doubt all these elements of all the charges against this defendant. Now, there's another step, and you all know it, and we don't have to overthink it. I know it is complex, but at the same time, we want to take it step by step and not overthink what we have to do. So what does it mean that she raised this defense? Well, you know that she has to prove something to you. Has she done that? And how can we tell? Again, I'm not going to read all this stuff. I usually don't put much writing on these slides, but because there is so much to get through, I want you to be prepared for what you'll have to read and talk about in your deliberations. The testimony from Dr. Knopfsinger is pretty fresh in all our minds because he finished his testimony today. The fact that this defendant has schizophrenia does not excuse her for her conduct. So now we are talking about kind of the battle of the experts. Let's talk about Sarah West. All right, you heard from her last week. Her opinions are based almost solely off of this defendant's self-reports. I don't know about you, but I got the sense from her testimony that she either hadn't watched the videos or really did not remember them and did not factor into her analysis of this defendant. You'll have her report to go through. When she was asked about basic things about these videos, she did not seem familiar with them whatsoever. And you've heard from Dr. Knopfsinger how crucial these videos are. This timeline, the methods that this defendant goes through to make her decisions. Dr. West seems to not put much weight in that at all. So that's what I mean by she does not use corroborative evidence from June 3rd. But she agrees with us that June 3rd is the day we're going to focus on. We're not really talking about too much that happened before. We're going to talk a little bit about afterwards, but really June 3rd is what we are really focusing on. Something that struck me about her testimony was that Dr. West said, I see a lot of psychosis here. And I didn't really know what she meant by that because, again, she didn't use corroborative evidence. Not one witness in this trial testified that Bionca Ellis was talking to herself or muttering things, talking to anybody. So Dr. West's suggestion that she was hearing voices didn't make a whole lot of sense to me. And we talked a lot about anger and rage, and that is really the crux of Dr. Knopfsinger's report. And we know that Bionca Ellis was not medicated on June 3rd, but we believe she was very angry, and that motivated her to commit these crimes. But Sarah West doesn't talk about anger. She kind of agrees with us eventually that anger could cause someone to commit a crime. But again, she is not focusing on anything but old medical records and the defendant's responses. Do you remember Dr. West talking about disorganization? That was a big theme of her report and her presentation. And she didn't really define it. And she also said things like, I believe, and maybe so, and probably. Ladies and gentlemen, the preponderance of the evidence is a different burden than the state has to prove when we are proving the elements against this defendant. Think of the tipping of the scales, okay? It doesn't have to be much of a tip. If you don't believe Sarah West, the defendant has not met her burden in this case. And I submit to you that she has not met that burden. Her theme doesn't make a whole lot of sense. She kept saying that this defendant was disorganized. And I did not find that to be helpful because she didn't really explain it, but Dr. Knopfsinger does. What does he say in his 36-page report where he overturns every video, every record, every interview, and he analyzes it through his expert lens? And again, you can see his report, you can read every word. He talks about what disorganization means. It is word salad. It is gibberish. It's nonsensical. His examples that illustrated this were someone that is loitering or trespassing, doesn't understand what they're really doing. They're kind of aimless. Bionca Ellis isn't aimless, she's angry. She's not disorganized. She's committing a specific willful act. She is not a disorganized person. And Knopfsinger really delves into that for us. So here we are. There's two prongs, as you know. I know you paid good attention in this case. And it's the second prong that we are really focusing on. There is no question this defendant is schizophrenic. That's prong one. Bionca Ellis suffers from a severe mental disease of schizophrenia. However, the fact that she has that diagnosis does not mean that she didn't know what she did was wrong on June 3rd. Pay attention to her interview with Dr. Knopfsinger. Okay? She's not being paranoid. I thought some of the best testimony that made sense to me was about, oh, she's not talking about, there's aliens or there's ghosts or whatever there is that I'm protecting these people from. There's no delusion. There's no grandiose explanation for what she did. She doesn't think that these people are harming her. Those were examples Knopfsinger used to explain why someone might act the way she did if they truly were insane at the time of that act. We have none of that here. None of that. She is fueled by anger. She is dehydrated. These are her words. You'll watch the video. She's dehydrated. She's hungry. She hasn't slept. It became a perfect storm. keep in mind, Dr. Knopfsinger has testified for the defense and the state, his 30-plus years of being a psychiatrist. He has seen a lot of different things come across his desk. He has no interest in the outcome of this case beyond the work that he did, the report he made. He's telling us what is based on his experience, his training, his knowledge. This is not an NGRI defendant, and here's why. Today, he told us that in order to be successful on this affirmative defense, she's got to prove that what she thought, what she did, was right. And she has not explained that in any way. There is no rational motive. I'm sorry, the rational motive that she provides is what we need to focus on. Hungry, dehydrated, missing money, it all comes together. And when she's angry and she sees those people, the relationship, the close relationship in time, that's what we have. That's why we're here. So, ladies and gentlemen, you'll have all the evidence. You can go through all of it. I know there's a lot. There's body cam and there's interviews. Watch her interview the next day. I want you to do that because she's still very angry the next morning. And I remember we played the interview in court, how loud it got towards the end. You could hardly hear her in the beginning. And then later on, she's shouting, stupid people, liars, thieves. And again, the way she acts directly after this. Dr. Knopfsinger pointed it out, and I think the other witnesses explained it as well. She is not saying, no, don't arrest me. I didn't do anything. She doesn't run away. But she does walk away calmly. She doesn't stay on scene at the car. She succumbs to the officer commands. She never protests her arrest. And Knopfsinger tells us that these are behavioral factors that indicate that she knew she did something wrong. The actions of stabbing. What a personal, gruesome thing to do. And I think on cross-examination, Mr. Johnson talked about, well, wouldn't 30 stab wounds be more indicative of rage? No. Ladies and gentlemen, stabbing anybody with anything is an act that would be fueled by anger. To have a 10-inch knife with a 7-inch blade and to select the most helpless victim possible and then stab that victim twice, that is rage. That's what we have in this case. All right, so here we are, at the very end, kind of to recap our timeline. She's upset. She goes directly to the knife houseware aisle in Volunteers of America, and she carries out her crime. Ladies and gentlemen, I urge you to go through all of the evidence together. I know that within your collective memories, 12 of you, some of you may have taken lots of notes, some may have not taken many notes at all, and that's all right. Listen to one another, talk to one another. Go through every video, the reports by the doctors, and discuss. Think but don't overthink. Bionca Ellis is responsible for the death of Julian Wood. And Mr. Mack told you that, if you remember, in his opening statement a week ago. But she did it with prior calculation and design. She knew what she was doing that June afternoon. Hold her accountable for what she did to that child and his mother. She knew what she did was wrong. Find her guilty. Thank you.
Thank you, Ms. Mateo. Mr. Mack, Mr. Johnson?
Please the court,
Thank you.
State of Ohio, members of the jury, good afternoon again. When I first learned of this incident, I learned through the media like a number of you, and I said to myself, what crazy person would kill a 3-year-old child? Those were my words. I said, this world is going to hell. And as fate would have it, I get assigned to the case. And then I began learning about this woman right here. I came to understand that there was mental illness. I came to understand how this came to be. The elephant in the room is this. You have a 3-year-old child whose life was taken from him. Not by his fault, not by his mother's fault. Bionca caused the death of that child. And we all know that this family doesn't deserve this. I implore you to embrace your humanity. It's okay to feel the pain that they're going through. If watching life-saving measures, trying to save a kid's life, if listening to a mother asking if her child is alive doesn't move you, then I question your humanity. If seeing photos of a deceased child, listening to a parent's pain, listening to a mother having to leave out of this courtroom, if that doesn't move you, then I don't know what could. Again, I question your humanity. Knowing that the bail can't be unwound. Because I know a lot of lawyers will tell you, you got to set this aside. You can't set that aside. But guess what? You have an oath. And no matter how much courage it takes or how challenging this is for you, you said during jury selection that you would follow that oath. Now, Mr. Johnson and I, we have to concede that this case emotionally is difficult. I watched you cry during this case. I've been practicing for 31 years. This is one of 3 cases where I felt as you did. That's okay. But you also made a pledge that when you make a decision in this case, it will not be based on sympathy. And you can feel the emotions that you must have experienced during this trial, but still make the correct decision. So, when Ms. Patel tells you that Mr. Mack said in his opening statement that Bionca's responsible, that's true. Even though it's not evidence, that's true. Now I'm telling you in my closing argument that she is responsible for the death of Julian, and you should find her guilty of murder, keeping in mind not guilty by reason of insanity being a defense. And you should find her guilty of the felonious assault as it relates to Margot and a number of the other charges. The aggravated murder and the attempted murder, I'll talk about that later. Look, when this case began, Bionca had options. She could either plead not guilty, she could plead guilty, or she could plead not guilty by reason of insanity. By now you know what she chose. Your job is not to focus on penalty, no matter which side you come down with respect to this. The state's strategy in this case has really been to normalize Bionca. They make the acknowledgement, and they have to concede because they can't get around it, that she's mentally ill. But they want to normalize her behavior on that day. She was in control. She was well organized. Her mind was working separate and apart from her schizophrenia. There was nothing normal about Bionca Ellis on June 3rd. There's nothing normal about her behavior. I want you to look at Bionca Ellis. 1 week from the date of the incident. She's at her arraignment. She's smiling at her arraignment. Even though it's been put forth to her that she could possibly receive the death penalty. Who smiles? Who does that 1 week after this incident? Not someone normal. But guess what? More than a year later, she's medicated now. This is what you've seen throughout the course of the trial. Take a look at it. When someone's medicated, they're compliant, their schizophrenia is not active, they're not hallucinating. Those are two different people. But even then, 1 week after, weeks after, months after, her mental illness was still active. It hadn't even ceased by the time that June 10th came around at her arraignment. They want to tell you that Bionca has to tell you what exactly she's hearing in her head. Bionca has to give you this theme that they've come up with that's not even in the diagnostic statistical manual. There's no authority for that. You can believe some, none, or all of what a witness says, even if they're an expert. Even if the narrative is trying to logically make sense. Think about it. And the doctor is mistaken, because I won't say the other word, but he's mistaken. Those are his words, well organized. He says that Bionca was well organized when you look at her behavior on June 3rd. He's the one that introduces rage. I couldn't get up and say it, but if you look at that interview, he introduces this concept of rage. Those are his words. She feeds him back what he's discussing. And if someone is well organized on the date of the incident, she rolls up to the police station in a wheelchair, and eventually she pushes that wheelchair. She has some conversation about the money. And then she leaves her wheelchair and her suitcase at the police station. She walks into Volunteers of America. She selects a couple of knives. She walks out. She walks into the next store, Things Outlet, with knives. And then she goes to Giant Eagle. Eventually she sees Margot and Julian, follows them out, and the incident occurs. The state would have you believe that this was all volitional, normal behavior. she goes into Volunteers of America. And she does, in fact, select 2 knives. Their theory is that this is about her anger about what happened at the police station of not getting her money. She walks into an unauthorized area while in Volunteers of America. She always has the knives out in the open. The first person that she has interaction with is the manager at Volunteers of America, an elderly woman. She doesn't stab her. She walks around the store. She stabs no one in Volunteers of America, and she takes a knife and she walks past the cash register. In the open. Both knives. It's not normal behavior. There's something that's going on there. And then she walks into Things Outlet. And the prosecutor would have you believe that, oh, she's hiding knives. If she wanted to hide knives, she could have concealed them underneath her clothing. She has both of her hands on her hips. When you go back there, look at that video. Her hands are on her hips, and she's looking around. Because whatever's happening right here is dictating her behavior. She doesn't see what she's looking for. She comes out, she taps a knife on the pillar, and she loses 1 knife. She walks with the knife in the open, outside. Now, the doctor can talk all he wants about, well, it's crowded inside of the store. You saw how many cars are out there in the parking lot. Bionca can't predict who's getting in and out of their cars. It's crowded, it's in the middle of the day, it's 3 o'clock. And I know you had to pay attention when she's walking with the knife, when she enters the store, and she walks past what appears to be an elderly gentleman, a woman coming. None of those people get stabbed, despite her motive being rage. Only when she sees Margot and Julian does she do this U-turn. Now, I want to pause there for a second. Because I'm not going to pretend like I'm a psychiatrist or a psychologist or any kind of doctor for that matter. But you're allowed to use your collective minds, all 12 of you, to try to figure out, based on the evidence, what was going on there. Why is it that Bionca, if she's so upset about her money, why is it taking her so long to stab somebody? We know it doesn't happen at the Volunteers of America. We know it doesn't happen at Things Outlet. We know that she doesn't go back to the police station and take her anger out on the people that wouldn't give her her money. So what's going on? You're allowed to consider whether or not she was hallucinating, whether or not she was experiencing a command hallucination that led her to the sacrifice of the death of the first child that she saw. You're allowed to consider that. And maybe my thought isn't the best about that. But it feels to me like in her mind, whatever she's hallucinating about, it has something to do with the child. Because she avoids all these other people that she could have taken her rage and her anger out on. Take 2 steps back and ask you, I just really want you to think about this. Does it make sense for Bionca to be angry about money that she didn't receive from the police department, to seek a 3-year-old child out and stab a 3-year-old child because she was feeling that anger and that rage? Commonsensically, does that make sense? We know that immediately following the incident, she walks away That's what the state of Ohio's witnesses told you. She walks away as if nothing had occurred, like a walk in the park. And she continues to walk with that knife in hand. And the only time that she puts that knife down is when she's confronted by the police. That's not the behavior of someone who's criminal-minded. I haven't handled any cases like that. Someone walking away from the incident and doesn't put the weapon down and they walk away. Whatever's going on in their head, it is still happening at that moment in time. If you were to take Dr. Knopfsinger's opinion at face value, the only way that she could have been psychotic or having this insane moment would have been for her to stab Julian in the store, sit down right there, don't run, make sure you leave the knife because you don't want to leave fingerprints, and then tell the police or whoever else would listen that she had this experience of wanting to kill a child. It's easy for someone that's been practicing medicine for 30 years to get up here and mislead. Because I guarantee you that what he says should have happened, it's not required in the DSM-5. This very authority that he has to rely upon, there's nowhere that says that you are required, if you're mentally ill, to articulate what you're hallucinating. You can believe some, all, or none of what a witness says. And again, I have to be mindful that you are deeply impacted by the fact that a 3-year-old child lost his life. I get that. That's why she's admitted to the murder of Julian, admitted to the felony assault of Margot. But you just can't brush not guilty by reason of insanity under the rug because it exists in this case. Even at the police station. She's interviewed for a period of 6 to 7 minutes. Keep in mind that she never says a word to anyone other than the manager at Volunteers of America, where she allegedly asked, "Where's the rest?" But throughout this whole ordeal, she doesn't have a conversation. In that interview, the detective tries to interview her, and her focus is on the money. And eventually she says, "You can put the Giant Eagle investigation into that investigation." That makes no sense. And when she yells attorney, she's not talking about the Giant Eagle situation. Please watch that interview. She's talking about the money situation. You got to keep in mind that this woman was in jail May 29th. And there's an officer that identified the fact that she's not mentally well. It's just a couple days before this incident. The state has made a concession that there's severe mental disease. They acknowledge that there's schizophrenia. You heard from Dr. Tesla, you heard from Dr. West, that even when they interviewed her, a month later, her psychosis is still active. She's still mentally ill. She's still disorganized, and Dr. West does explain disorganization. Whatever was going on in her head never stopped. And keep in mind that no one ever came here and told you that insanity has to last for 5 minutes, 30 minutes, 2 days. I appreciate the prosecutor coming up here and talking about aggravated murder, but that argument is not a good argument. You don't need me to tell you that there was no prior calculation and design as it related to the death of Julian. You see how random she chose them, and that's at a spur of the moment. And no one can say what was in her head when she was in Volunteers of America. How is she going to tell you what was in her head in Volunteers of America if Dr. Knopfinger or Dr. West could? Don't fall for that. The reason why I said the attempted murder, the reason why I say the attempted murder is not a good charge because the focus appeared to be always on Julian. Margot, to her credit, did what any good mother would do. She tried to save Julian's life. And she got stabbed in the process just one time. If Bionca wanted to murder her, she would have stabbed her several times. And I don't know what world they're living in when it comes to rage. Rage is not 1, 2, or 3 stabs. It's horrific what happened, but that's not rage. It's very important that you understand preponderance of the evidence. Please read that instruction. If it had to be quantified, more probable, the greater weight of the evidence, those are terms that you've heard. If it had to be quantified, it's 51% to 49%. That's our burden. Far less than what they have to prove, which we've conceded to a number of the accounts for proof beyond a reasonable doubt. You cannot make a decision without considering that burden. I welcome you to have, in one hand, Dr. Knopfinger's opinion, and in another hand, have Dr. West's opinion, and see which one makes the most sense. You're going to see, when you have the jury instructions, you can just focus on me, then I'm going to go to his opinion. You're going to see words in the instruction that talks about, NGRI can't be motivated, so no motive. You know that there's no motive to take the life of Julian in this case. There's never been one established. Even though generally the state doesn't have to prove motive, you have to take into consideration what's in the jury instructions. We know that this wasn't some impulsive behavior. Margot did what she was supposed to do. She took her son to the store, was shopping. She did nothing to provoke Bionca. So there's no emotional response that can be identified through the evidence. There's no impulsive behavior. And again, the word rage is something that Dr. Knopfinger introduced. We don't agree with that. We don't agree that she demonstrated rage. We agree that her act was wrong. The opinions in this case between both doctors are not equally balanced. You see language like that as well. Again, put those opinions side by side. And I guarantee you that if you truly objectively read them, you'll understand that Dr. West speaks of the insanity aspect of this much better than Dr. Knopfinger does, and it makes more sense. So, in his opinion, pages 35, 36, and 37, and he sort of speaks two ways about this. But on page 35, under 2A, he talks about how Bionca interacted calmly with staff through a window. She did not display any objective signs of her severe mental disease. I don't know how he would be in a position, based on the video that we saw, for him to make that determination. But he thinks that because he's a psychiatrist and his words are powerful, that you're just going to latch on to that, especially with these inflammable facts. He goes on to say in section B, she not appear distressed or internally stimulated in Volunteers of America. On the one hand, she's walking with strong purpose. She's got this rage, but she doesn't appear to be distressed. He goes on and Section D talks about she still does not appear to be distressed, internally stimulated, or out of control. In the Giant Eagle surveillance videos, he says that Bionca was well organized in her actions, did not appear to be internally stimulated, hallucinating, or disinhibited. What's well organized about walking into a store with a knife in your hand, walking with a knife where everyone can see the knife, and just walking around aimlessly until you latch on to those two people? What's well organized about that? Again, in Section E, he talks about how Bionca didn't report symptoms of severe mental disorder, nor display objective signs of severe mental disorder. That's not required. Otherwise, he would have cited that as being authority from the DSM-5. How would he know? And this requirement of her having to report her symptoms, it'd be fine if he identifies some authority that they can all agree upon, but you will not see that in his report. We're on to page 36, under 3. He indicates that, and we've talked about this, defendant approached the victims from behind, which indicates the defendant believed the victims would perceive the offenses were wrong. Again, just look at the totality of the evidence. Look at the knife in hand. When she first walks by them, the knife is not concealed. In section F, under 3, he talks about how she didn't announce her presence. I just want you to look at all these factors, and you tell me, even commonsensically, if this makes sense. Dr. Knopfinger had the benefit of interviewing Bionca. When she's medicated, she's better able to communicate. Never had the ability to interview her early on, like Dr. West. He's got the benefit of incorporating everyone else's reports into his own report, and that's the reason why it's so long, amongst other reasons. Mr. Johnson's going to get up here and he's going to tell you about the not guilty by reason of insanity through Dr. West's eyes. And I would ask that you listen to him. And I appreciate your time. I believe that at the end of the day, she should be found not guilty by reason of insanity. Thank you.
Thank you, Mr. Mack. Mr. Johnson? Final thoughts?
May it please the court,
Thank you.
State of Ohio, Cook County. Ladies and gentlemen of the jury, I too want to thank you because this was a difficult situation. And every last one of you paid close attention to everything that was displayed. You heard from experts. You've seen evidence. And you witnessed the painful details of a tragedy. But make no mistake, we're not denying that this tragedy happened. It's about understanding the mind behind the tragedy. We heard from doctors, psychiatrists. Everyone said something a little different. But you have to use your common sense and judgment. At the end of the day, we have the tale of two doctors, and it has to make sense. The law asks you to determine whether Bionca Ellis, at the time of the offense, was suffering from a severe mental disease or defect. and renders her incapable of understanding the wrongfulness of her actions. That's the legal standard. Now, Dr. West, Dr. Testa, they both seasoned psychiatrists. They testified through the throes of schizophrenia, paranoid delusions, disconnected from reality. These symptoms weren't new. We learned over the years, she's been going through this time and time again. We have jail logs. She's in different states. Behavior does not change because she's on medication. Now, Dr. Nalsiviger says, well, that's not a part of schizophrenia. But when you look at the evidence, when she's unmedicated, she's not in the right state of mind. You heard from him, 3 people were assaulted at North Coast Behavior when she was not on her medication. Dr. Nalsinger dismissed these symptoms as self-serving. He said he relied on surveillance footage, jail calls. Look at how he interpreted those things. It's through a lens of skepticism. He told you, well, I looked at the video and I didn't see any signs. I didn't see anything where she was talking to herself, but I asked him, I said, well, there's no audio, it's not the best video. How do you know what she's hearing? No, based on the facts, I don't think she has any excuses for her behavior. And the problem with video is, when I slowed it down and showed him a still shot of her in the thing's outlet, she was looking up and to the right. Well, that doesn't make sense. If she's going there looking for water, and I asked her, I said, well, water's not going to be up and to the right, is it? Well, no. Well, what if, I asked him, what if she's hearing something and she looks up to see what's talking to her? But he dismissed that. And I think he didn't slow the video down. Videos, when in constant motion, you don't see everything. The illness clouded her judgment. And she did not know the wrongfulness of her actions. Because we heard from Dr. West. She's a seasoned psychiatrist. She spent a lot of time with Bionca. We spent time together with Bionca. And the video you saw her in arraignment, that's the Bionca I met. That's the Bionca that Dr. West met. She wasn't in her right state of mind. But the person you see right here is not the same person. Why? Because she was medicated. Now, Dr. Nalsinger said she scurried away from the scene quickly. And I asked him, I said, wait a minute. Let's look at the video. Let's bring it back. He said she rapidly walked away, trying to get away, trying to evade detection. But that doesn't make sense, ladies and gentlemen. She's walking with a bloody knife in her hand. She's not running. Now, you've seen her at the police station. You seen her, she skipped down the steps rather quickly. So we know she can move at a fast pace if she desires to do so. But that wasn't the case after this. She walked away slowly. Mr. Bush pulled up and said, hey, you know you just stabbed that kid. It wasn't a rational answer. Shrugged her shoulders. You had to ask yourself why. What state of mind was she in? She didn't know she just did something wrong. These behaviors are also consistent with psychosis. Individuals suffering from schizophrenia may still follow commands and flee due to paranoia. We heard that from Dr. West. She told you, Just because a person's in psychosis don't mean they can't follow instructions. Now, Dr. Nelson said, well, these things are self-reported. He basically said, I take it with a grain of sand, but I didn't believe anything she said. But he said, you got to ask her, because that's one factor that they look at. Well, she didn't say the right things. He made it appear that there's a playbook of what people with schizophrenia and people who are delusional are supposed to say when they commit a crime. Well, this is not the Browns. There's no playbook. She told him in that interview, you're going to have that interview back there. And she keeps saying over and over and over again, I blinked out. I heard voices. That skeptic eye goes, I don't think so. Not a good enough answer for me. But he said, Dr. Nelson acknowledged, that's a key factor, self-reporting. But he didn't listen to her. He didn't take any of it in for his conclusion. He dismissed it. Now keep in mind, he had her longer than most people interrogate suspects. She's in a cold room for 3 hours, no water, no break, and he's pressing her. He's pressing her. You think she wasn't tired of sitting there wanting to go? Listen to the video. He introduced rage. He brought it up because he knows it's one of those elements in the law that you're going to read about that you can't use. Mr. Mack talked about the motive. Well, she was angry about this money. The fact that she walked past several people and didn't do anything has to mean something. The fact that when she walked in, she's swinging a knife around. That's not organized behavior. If you're planning to kill someone, you're not walking into Giant Eagle with a big butcher knife swinging, because it screams out, hello, what's going on? The sad thing is, no one in Giant Eagle even paid attention. I don't know if it was trying to avoid looking at her, trying to act like she wasn't there. She walked around with a butcher knife, and I'm thinking, who can walk through a store with a butcher knife and the police not be called? The police are less than 2 minutes away. I'm thinking, did Volunteers of America have loss prevention? She walked right past the cashiers and not even stopped to pay. No one called the police and said, hey, this lady just stole the butcher knife. So when you talk about this timeline, this is a sad sequence of events that somehow it could have been prevented, but it wasn't. So we're stuck with what happened. And what happened was a tragedy. And it wasn't because she wanted to kill someone. It wasn't because she set out that day to kill someone. She told you, and you're going to hear in the video, she goes, I didn't think I would throw my life away like this. I had other plans. I didn't think I would throw my life away like this because I had other plans. She wanted to move to Florida. She talked about Disney. I put in applications for Disney. Dr. West states in her opinion, with reasonable medical certainty, that at the time of the events on 6/23/2024, Ms. Ellis was suffering from severe mental disease, schizophrenia. That's just one problem. We know that because everyone talked about the one problem. We know for 10 years she was schizophrenic. But what Dr. West did was to listen to Bionca. She listened to her rationale behind what she did. She listened to her about saying there's voices. She talked about the suicide. You're going to hear all this. You're going to have both. You're going to have both reports there. You got to use your common sense and judgment and say which one makes more sense. A lot of the reasons that Dr. Nelson put out there, it didn't make sense. It didn't make sense. No one was trying to hide. No one was trying to run. He goes, well, when she got apprehended, She didn't say, the devil made me do it. She didn't say anything. That's a part of her disorganized thinking. When she got to the room the next day with Detective Jones, her mind was on, where's this debit card? Where's this money that they took from me? He cannot say with a degree of certainty that he knows what she heard or didn't hear. Because when you look at that still shot that's in our photo, she's looking up to the right. Something has her attention. She's not looking straight ahead. She's not trying to hide the knife. He said she's hiding the knife. And like Mr. Mack said, it was behind her back. Her hands were on her hips. The knife was in her hands. Listen closely at her interview, because she explains away everything, what she was thinking. But when she gets pushed, when she hears those words, well, I'm about to give you some pushback. She listened to the authority. She let him push back. At the end, and you're going to have Dr. West's opinion, she opined with reasonable medical certainty that the time of the incident, 6/3/24, Miss Ellis had a severe mental disease, schizophrenia, and it caused her not to know what she was doing was wrong. Ladies and gentlemen, based on those facts, everything that you heard here today, you have no choice, and we'd ask you to find her not guilty by reason of the sentence. Thank you.
Mr. Johnson, thank you. Lastly, Ms. Corrali, we'll hear from the state.
Counsel for the state, Detective Ventris. Counsel for the defense, Defendant Ellis. May it please this court.
Thank you.
Good afternoon, ladies and gentlemen of the jury. Our journey of the last week and a half is coming to an end. Our jobs as advocates in this case are coming to an end. And make no mistake about it, folks, we are advocates for each of our sides. But your job is just beginning. Though you have toiled with us for the past week and a half, you have traveled to this courtroom every single day. You have listened attentively. You have taken notes, some of you more than others. And at times, there was a bit of levity. But just because there was a bit of levity does not mean that this case isn't serious. One member of our community died on June 3rd of 2024, and that was 3-year-old Julian Wood. His mother, Margot Wood, was stabbed, and she survived at the hands of defendant Bionca Ellis. You know, folks, everyone has thanked you, each of you, for your time and your energy and for your effort that you've given us. We've imposed on you folks, and you have made the sacrifice in your personal lives for us. And your sacrifice isn't over yet. After I'm done speaking, the judge will continue to give you some further instructions, and then the case is going to be given to you, and it will be in your hands for deliberation. You don't have notebooks at this particular junction because, as you already know, opening statements and closing arguments are what we think, what we believe, not what you heard from that witness stand. If I say something in closing argument, or for that fact, an opening statement that you didn't like or you didn't agree with, you rely on your 12 collective memories, because that's what our jury system is about. It's about you and what you hear in this courtroom to make a determination between the state of Ohio and this defendant, Bionca Ellis. I am going to share just a few things with you that I saw and that I heard in this courtroom. And by no means am I here to misrepresent anything. I want you to rely on your 12 collective memories. Some of you have taken copious notes. What have you seen in this courtroom? What testimony have you heard? This courtroom has been your oyster for the past week and a half. You can believe some, all, or none of what has been testified to. That is your prerogative. You are the sole judges of credibility. I want you to use your common sense and your good judgment that you use in your everyday life to make a decision in this case. And I know that you will make a decision in this case. In opening statements, I told you folks to pay close attention to Bionca Ellis's actions. Mrs. Pateo stated in her closing argument this afternoon that the defendant Bionca Ellis killed Julian Wood and attempted to kill Margot Wood on June 3rd of 2024. We told you from the beginning that the one principal issue in this case is not going to be who did it or whether she did it. It's the issue of legal insanity. What that encompasses, folks, is that this defendant, with a plea of not guilty by reason of insanity, is asking you folks to relieve her of her responsibility of accountability for the death of Julian Wood and the attempted murder of Margot Wood. If the state proves all the elements beyond a reasonable doubt, she's saying, hold on, folks. I was legally insane, therefore should not be held responsible. But you folks recall that the burden is their burden. to prove those two elements of legal insanity by a preponderance of the evidence. That scale has to tip. If it doesn't tip, they can't have it. One prong is not good enough. You need to focus on both prongs of the test that have to be met. If you do not have the second prong, she is guilty of each and every count. You heard the defense tell you, yeah, she's guilty of the murder, folks, but not guilty because of reason of insanity. They don't have the aggravated murder. We have the video. You decide. You decide how she acted that day. And was she hearing voices? And by no means am I disparaging anybody's mental illness here. I want you all to believe me from the bottom of my heart, because there are folks that walk around us each and every day with mental illness, and they don't kill people. What were her actions that day? You evaluate those actions on June 3rd, 2024, because that's what the law says. No one is disputing that she has been diagnosed with schizophrenia since she was 19. Not Dr. Nossinger, not Dr. West. Nobody's disputing that. But the issue becomes, did it affect her so much that she did not appreciate the fact that she stabbed a 3-year-old twice and a woman once? I submit to you, she knew exactly what she was doing. And it took her 8 months to come out with, I was blanking out, I was hot. I'm not diminishing her illness, but keep in mind, the excuses came 8 months later. Look at her actions in Volunteers of America. You know, I think in this courtroom, folks, for the last week and a half, we've been playing semantics. Tossing, throwing, dropping. You decide. You decide what she did that day, because you get to watch her as she's picking out knives. She's looking at the knives. Which knife is better for me? This isn't something I made up. I didn't go out and choose that Bionca Ellis was going to be the next defendant that I prosecuted in my tenure at the prosecutor's office, which has been long. And I didn't pick the Wood family to be the victims of this case. I get assigned cases because defendants bring themselves into this courtroom. So you have the two knives. We can agree on that because we have video. So there's not much dispute about the video, because then it becomes interpretation. Interpretation by the state, interpretation by the defense. At the end of the day, the only interpretation that is important is yours. What do you see on those videos? Because if we didn't have the videos, then that would be a different ball game. But we have the videos. You have her actions. When she goes in to Things Outlet, the knives are on her back. Yes, she's positioned like this, but the knives aren't swinging here at Things Outlet. She is looking around to see who she's going to pick on. She goes outside. She stabs a column to see the pliability of a knife. That is somebody who wants a good weapon. That's not somebody who's just hitting the column. And then she goes inside of Giant Eagle, and you determine, because she's thinking about it. It's like hunting, calculated, manipulative. She goes in and sees a child in a cart that can't get out of a cart because his legs are coming out, and a mother pushing it. Soon as she sees them, that about face is so quick and follows them. But then she's too fast for them. So what does she do? She holds back and waits for her prey to continue to move on, and then she follows right along. There's nothing disorganized about that. That is focused. That is laser focused, ladies and gentlemen. And then she goes into the parking lot. And you heard Mr. Stroud and you heard Mr. Bush. They have no stake in the game. They told you what they saw. Never was she talking to herself. Never was she mumbling. Yet she took a knife and she plunged it into the back of a 3-year-old. That's what they did see, standing over her. Over him, I'm sorry. You heard the medical examiner. She's got no stake in the game. She told you that that butcher knife went into that child's body 4 inches that severed the carotid and 4 inches that stabbed the lung. She walks away nonchalantly. She walks away, not in the aisle that she committed the crime, the next aisle, and she walked with a bloody knife. When the police arrive, she follows commands. And during the interview on June 4th, she talks to Marjorie Jones. You, ladies and gentlemen, have to watch that video. And what do you see? What do you see in that video? And where is her focus? I disagree with Mr. Mack. When he says that Dr. West talks about this disorganization that she had. I thought she was pretty gosh darn organized about what she was doing that afternoon. And you know what, folks? Dr. West said that self-reporting is not enough because she co-wrote an article with Dr. Knopfsinger, who's been practicing for 30 years. And make no mistake about it, folks, he doesn't have a stake in the game either, because he's testified for the state, for the court, and for the prosecution. He is a professional. And when you compare reports, it's not about how many pages it is. It's about the methodology. And you heard her. She agreed with me. Methodology is very important. Finding corroboration objectively is important. You decide, ladies and gentlemen. The defense wants you to believe that I want to normalize Bionca Ellis. I don't want to normalize anybody. Her actions normalize herself. Because like I said before, many people in our country suffer with mental illness every single day, but they don't go out and murder people. No one is going to stand before you and tell you that Bionca Ellis is not a schizophrenic. I'm not here to tell you that. She is. She was her own payee. She was living her own life, doing her own thing. Going to California, going to Florida, functioning herself. Nobody had a guardianship over her, you heard that. But on June 3rd, 2024, Bionca Ellis killed Julian Wood and stabbed the mother. It was aggravated murder all day, every day. The murder and the felonious assault, yes, somebody got hurt and then they died. That's murder. You have the interview of the 4th. You have all the body cams, all the videos. You have both reports. Ladies and gentlemen, at the end of the day, ladies and gentlemen, as this case is winding down, we recognize in a civilized society that we rely upon the recourse of the law. We owe it from one generation to the next. The recourse of the law requires that you find the truth. In finding the truth, it really requires that you have faith in yourselves and faith in the law. What your decision is in this case completes the accounting for the death of Julian Wood and the attempted murder of Margot Wood. You've been on this journey with us, folks. The recourse of the law instills in all of us responsibility. And we don't lose that responsibility by claiming that we were insane at the time. That balance is off, folks. If they don't meet their burden of proof, not guilty by reason of insanity does not exist, and you find her guilty of each and every count of this indictment. And I ask you that. I ask you that for our community and for the mental health community. Because good people sometimes make really bad choices, but they know what they're doing. Thank you.
Thank you. Ms. Rowley, do you mind taking that? I'm sorry. Oh, thank you. Just, you can do the other.
All right, so ladies and gentlemen, I'm going to now charge you with your instructions to go back and begin your deliberations. Because this is a criminal case, the law requires that all 12 of you be in agreement before you can consider that you've reached a verdict. For the 12 of you, one of you will be picked as a foreperson. I'll talk about that in a moment, but each of the jury instructions are redlined. These are the originals that need to be returned to me as the court. We'll give you an envelope to seal them in so that you can give them back to the court. I'll talk a little bit about the directions. So whoever the foreperson is, there are a couple things that I'll advise you of regarding your choice as foreperson. But before we even get there, you have heard some discussion about punishment, and that may have come in different ways. I don't think any of the lawyers brought that up, or any of the witnesses who maybe have brought it up as well, in any way to diminish my responsibility. But you may not discuss or consider the subject of punishment at all. It is only your duty to carefully weigh the evidence, decide all those disputed questions of fact that came through this witness chair, apply the instructions that each of you will have to your findings, and then render your verdict accordingly when you return the verdict forms. For the 12 of you, your verdict and efforts must be to arrive at a just verdict, right? Considering all the evidence, and then make your findings and do that with intelligence, impartiality, without any bias, without any sympathy, without any prejudice for or against the state of Ohio or Miss Ellis. Both parties come here, both the state of Ohio and Miss Ellis, both of them come here and believe that they will leave here feeling that their case was fairly and impartially tried by all of you. When you do go back to the jury room, upon your retirement, you will immediately proceed to select one of your number as the foreperson. That person will preside over your deliberations. Whoever that foreperson is, you're sitting in this room right now, hear me. You have no greater authority or power over any other member of this jury, except I'm charging you as the foreperson with the responsibility of ensuring that each of the jurors is given an opportunity to express their opinion on the evidence. Of course, the foreperson, when you've reached a verdict, you're all going to sign this and make sure that as the foreperson, they're filled out correctly. Doesn't matter what order you sign. There's 12 signatures. Doesn't matter that you have to sign in the same number or the same place. But just when you've reached a verdict, you'll sign the verdict form in ink, which agrees to the finding that all 12 of you have. Now, if you have a question about these instructions that I give you, it has to be discussed between the 12 of you first in the privacy of the jury room. If all of you disagree, or some of you disagree as to the meaning of the instructions, it may be possible, under certain conditions, to review those matters by a request to myself. Know this, if you ask a question of the court, I convene all the parties first. We have a discussion about the question. We may bring you back in here and have that discussion about your question here on the record. I may provide you something in writing. If I've provided it to you in writing, it's because the parties have discussed it. But just know that you send a question to me, it's not going to be answered immediately because I'm going to bring everybody back in for a discussion about your question. But whoever the foreperson is, please write or print neatly, sign the question. That question is part of the evidence and stays part of the case. So once you sign it, date it, and we'll have the case number on it, and write me your question. We'll make sure we get it answered for you. If you desire to address any communication, again, as the foreperson, you must reduce it to writing, have it signed by the foreperson. And the question, again, is usually answered here in open court. And if I do give you something in writing, save the question and answer with the evidence. Again, after you've reached that verdict, you'll contact this room through Kathleen, and then your verdict will be read here in open court. After the verdict is returned, then you're discharged as jurors. Then you can discuss this case with anyone or not as you choose. But until a verdict has been returned here in open court, you may not discuss this case with anyone or let anyone discuss it with you. I'd like to go even like a step further. 11 of you are in the room. 1 of you is in the restroom. There's no discussion, right? You're not discussing the case when everyone is not present. So I give that distinction because it's very important that all 12 of you are present. Now, as alternate jurors, I am going to excuse you from the deliberation process as alternate jurors. When we recess, I'd ask that there be no discussions in that jury room until my 4 alternates have gathered their information or their stuff from the jury room and have exited the jury room. So you are not picking your foreperson until the 4 alternates leave. But for 4 of you, you still remain part of my jury. There is enough times in my career as a judge that there's a possibility that juror 1 has to step in for someone who's unable to fulfill their duties as a juror. So you're instructed for the 4 of you not to discuss this case with anyone. You're not to discuss what your verdict might have been or discuss anything about this case. When there is a verdict, we bring you back up into my courtroom so that you're part of hearing that verdict read. And then, of course, there are discussions that you can be part of afterwards. So when we're done here, I ask that you grab your belongings from the jury room. Ashley will bring you downstairs. We will have you down on the 4th floor, but we also take your phone numbers just to make sure that we put you on a group text and let you know what's going on when you need to come up. So again, grab your stuff and then leave. Again, you're still part of this jury, no discussions at all as we move forward. For the 12 of you, look, the law in constituting a jury of 12 jurors, it contemplates that each of you, all 12 of you, give your individual consideration to and upon the judgment in this case that you're going to render. It gives your individual consideration upon the evidence that came through this witness chair. The rules of law which are explained to you here in these jury instructions are binding upon each of your individual conscience and the judgment as members of this jury. While deliberating, please, each of you jurors should give careful consideration to the views which your fellow jurors have, even if it's not your decision or your thought process. A juror should not turn a deaf ear to their associate jurors. And then without listening to their reasons or their arguments, you obstinately stand upon your own opinion, regardless of what may be said by another juror or jurors. It must be the object of all of you to arrive at a common conclusion, and to that end, you should deliberate together with calmness, in a dispassionate manner, being considerate of each other's views. You should really have two propositions of equal importance in mind when you're deliberating. First, that the laws here are enacted for the benefit of all members of organized society. And when you as a jury are convinced beyond a reasonable doubt of a defendant's guilt, then you as a jury should say so in its verdict. And then moving to the second prong if you need to. Again, as a jury, being convinced by a preponderance of the evidence, you should say so in your verdict form if you find that. And secondly, that no defendant should be convicted of a crime when you, the jury, are not convinced of such defendant's guilt by evidence beyond a reasonable doubt. The verdict that you as a body reach is of your own. There is no right or wrong verdict as long as you've considered all the evidence that came from this witness chair. That you listen and follow the law that I give you, and as I have instructed you here this afternoon. And so I say to the 12 of you, ladies and gentlemen, this case is now in your hands for a verdict. If we'd all rise, please. We can be seated. I see counsel at side. All right, so for the record, again, as I thanked you at sidebar for your professionalism, all of you represent the law well. As a judge, we all hold the same professional degree, and I appreciate your respect for our degrees and for the professionalism in the courtroom. So thank you for this almost 2-week process that we've been in. That being said, I've given you an opportunity to review the jury instructions, and so as I read them, of course, I read them as correct as I can. So I just want to know if there were any objections to those jury instructions from the state of Ohio that I shared with the jury today.
No objections, Your Honor.
And on behalf of myself.
No, Your Honor.
All right, very good. I know we all have your numbers. I know you all have busy schedules. So you're going to be going somewhere else starting tomorrow, if not in 5 minutes, to some other courtroom. But at least remain in contact with Kathleen so that if we have a question or we have a verdict, that we can reach all the parties as well. Anything further then before we recess? Steve?
No, Your Honor, thank you.
Thank you. Anything from the defense?
Just all the way to the side, Mark.
All right, very good. Then we'll adjourn with respect to the case. Thank you.